on construction contracts. Just going to click a few buttons on my end because I believe Jess has now started the recording. It's asking me for permission. There we go. So yes, this session is focusing on construction contracts specifically, whereas in the last session we talked more generally about the law of contract, how contracts come into formation, having offer, acceptance, consideration and intention, and through to how contracts are discharged by repudiation and by agreement or by other means as well, such as performance. So as we say, we're really focusing on the construction industry today, and what we're going to be looking at includes common terms and features. You know, let's call a spade a spade. A contract is a fairly simple thing. It is only an agreement, and typically speaking, construction projects are generally structured in the same way, and the common terms and features throughout are quite similar. So I'm trying to focus on a couple of key words that you might see throughout your career, and a couple of key features that I see it as a construction solicitor that are common in construction contracts. There's someone just mentioning there in the comments that is the audio on because they cannot hear. I'm assuming everyone can hear me before I go any further into this. Perfect. There's a few people saying they can. Now first limited, I think the issue therefore might be on your end, unfortunately. Perfect. Moving on then, we're going to be looking briefly at standard forms of contract and construction, looking at the NEC, JCT. Jess mentioned previously the Irish government form of contract, that's the public works form. I'll also briefly mention that as well, just to really emphasize the point that there are different products available on the market, but at the end of the day, it is still doing the same thing. It is an agreement for a contractor or a consultant to do X, Y, and Z in return for money. How they go about doing X, Y, and Z might be subtly different, and it is all dealt with, and it can be dealt with under a standard form. Payment is an interesting one. It's interesting because payment in the construction industry, both in the UK and in Ireland more recently, is heavily regulated by statute. So if you're working in the UK, England, Scotland, Wales, or Northern Ireland, it will be dealt with under either the Housing Grants, Construction and Regeneration Act. If you are in England, Wales, or Scotland, or if you're in Northern Ireland, a slightly different piece of law, but it does virtually the same thing, the Construction Contracts Northern Ireland Order. I say more recently because in Ireland, we only recently had a piece of legislation passed that regulates payment in construction, and that is under the Construction Contracts Act of 2013. I'm going to talk you through all of that legislation to show you what it looks like structurally so that you understand what exactly the payment terms of construction contracts must look like. And that applies to both consultancy agreements and construction contracts for works as well. Both of those types of contract are regulated by the law that I've just mentioned. Then we will briefly look at making claims for additional time and money. I'm going to look at that in detail because that is one of the aspects of construction that does typically get quite contentious. So understanding what gives rise to entitlements, how you should notify them, and ultimately how you should prove them is of paramount importance for everybody in the audience. Again, if you're a consultant, making sure that you understand what your scope is, understand when you're being asked to do something outside of that, and understanding how to claim. If you're a contractor, understanding what you're employed to build or design, and if you're being asked to do something differently or the constraints change, making sure that you understand how to notify that entitlement so that you can claim additional time and additional money potentially. That then dovetails nicely into the final topic, which is dispute resolution, and I'll briefly talk through the various different options that are available for resolving disputes in construction. As I said at the beginning, I work as a construction solicitor. A very large part of what I do in my day job is dispute resolution, and I'm going to be talking about one very popular form of dispute resolution, which is adjudication in quite some depth. So strap yourselves in. That's what we're about to cover over the next 50 minutes or so. And as we talked about last day, if you do have any questions, and I see Jess is just putting it into the chat box there, I'm going to try to do these as I go along. So if you do have any questions, feel free to put them into the chat box and I'll keep an eye on that on screen. So in terms of the common features and terms that you will see within construction contracts, take this with a pinch of salt. It would be impossible for me to go through every common feature. So what I've highlighted on the screen here are just 6 bespoke or discrete topics that I think are worth mentioning so that everybody in the audience starts to get a flavour of what construction contracts look like and what we commonly see within them. So as I said at the beginning, the agreement itself is usually quite straightforward at its core. All of the other obligations that go alongside that are peripheral. At its core, a construction contract is actually quite straightforward. It is an agreement for the contractor or consultant to do X, Y, and Z in return for money. So if you are reviewing a construction contract, making sure you understand what that X, Y, Z is, making sure that you review the scope or the works information if it's under an NEC 4, the employer's requirements if it's under the public works or if it's under JCT, making sure you understand the core of the agreement is of the utmost importance. And then obviously in return for money. Now that has got a couple of different things that we can say about it. There's the upfront money that you will be paid for doing the work itself, but there's also the money that goes along with risk. Under a construction contract, risks will be allocated to one or both of the parties. It may be shared, but typically speaking, it will be one or the other. If that risk lies with you as the contractor or you as the consultant, you need to price for it. Because if that risk materializes, you may not be able to claim any further compensation off of the employer. So when you say that doing X, Y, and Z is in return for money, you do need to factor in when pricing the project, the risks that lie with you under the contract. And I'm going to come back to that topic in a bit more detail. I'm going to look specifically at how the likes of the NEC and the JCT contracts allocate certain risks between the parties. And by understanding that allocation of risk, you understand what you need to price, and ultimately that first bullet point becomes much more transparent. The next bullet point that we have on the slide here, and I can see Thomas Kelly is asking a question about this as well. This is retention. Before we get to your question, Thomas, just maybe to explain what retention is to people in the audience that don't understand that term. Retention is a pot of money that is normally withheld by the employer. So if the contractor makes an application for payment for £100,000 and pursuant to the contract, there is a retention percentage of 5%, the contractor will be paid 95. The employer withholds that pot of money, that £5,000 pot. The logic behind that is that pot of money can be used to correct any defects within the contractor's works. It would be uncommon to see it within a consultancy agreement, but it will be extremely common to see that arrangement with a contractor in a construction context. If there are no defects in the works, that money is usually paid back at the end of the project, or at least half of it anyway, and the remaining half will be paid back normally a year after the works are complete, or possibly 2 years. So that's what retention is for broad brush purposes. It's a method of security, giving the employer a pot of money to call upon in the event that there's something wrong with the works. That's the logic. There's arguments for and against having retention, but that's the premise of it. So the question here from Thomas Kelly is a slightly more complicated question. The retention money, who holds title to it? So the ownership of it, and is it governed by any law of trusts? So the answer, Thomas, is it depends what it says in the contract. The likes of the JCT contract is a prime example. It has wording to the effect that the retention money held by the employer always belongs to the contractor, and the employer's interest in that money is fiduciary in nature, which is a fancy legal way of saying that they're obliged to protect it, but it is not theirs. The NEC, in contrast, does not have that wording, Thomas. So under the NEC, the wording or the money itself is not deemed to be the contractor's. So if the employer went insolvent at that point, it could be an issue for the employer in recovering that. The only way they could potentially do it is to try to mount some sort of argument in the law of trusts that the employer's interest in that money was only fiduciary in nature, but there's no express wording to that effect, and it can be difficult. So that point illustrates a point we'll make later quite well, that there are differences between these standard forms. You know, retention as a prime example is very different under the JCT compared to the NEC, at least in its unamended form. You would normally see that part of the JCT tweaked and removed. Relief events is another example of how these standard forms differ. What I mean by relief events is this: there will be certain events listed or scheduled within the contract that the contractor is not deemed to have priced, or the consultant is not deemed to have priced. And if one of those events arise, it will entitle the contractor or the consultant to claim more time or more money. You've probably heard the term if you've been in the industry for a while. We call those events under the NEC the compensation events. I'd like to think that most people that deal with that contract have heard of a compensation event. And those are effectively events that will entitle the contractor to relief, both in terms of time and in terms of money. And another point that we will look at shortly is how that differs under the JCT. Because under the JCT, there are no compensation events. There are things that are slightly similar, but they are different enough to warrant discussion. We call those the relevant events and the relevant matters. So there's no compensation events here. There's two categories: relevant events and relevant matters. The relevant events, such as weather, for example, under JCT, will only entitle the contractor to time. They only get an extension of time for that, whereas a relevant matter would be time and the money associated with it, the associated loss and expense. So there's another example of how these two very common contracts are completely different in this respect. Under the NEC, all of those relief events are time and money, whereas under the JCT, some of them only give rise to an extension of time. This mechanism of giving the contractor or the consultant an extension of time for one thing and time and money for another is a very common feature in construction contracts, and understanding how your specific contract deals with those relief events is extremely important. It will be subtly different under all of the standard forms: NEC, JCT, FIDIC, RIAI, RIBA. They all deal with this issue very slightly differently. Question here, another one from Thomas, in relation to weather: if a relevant matter crystallizes into a relevant event like weather, how is it dealt with? I'm not quite sure I follow that question there. So Thomas, weather, exceptionally adverse weather under the JCT, is only a relevant event. It is not a relevant matter. So if you are delayed on site due to exceptionally adverse weather, if it's too windy, for example, and you can't use your craneage, then you would only get an extension of time for that, no money. So I'm not too sure how that links into your question. If a delay in a decision is increased by weather, again, you'd be into a matter of concurrent delay there, which is a separate topic in its own right, trust me. But the chances are you would only get the time associated with that. The answer to that question might actually differ depending on whether or not you are in Scotland or in England and Wales or Northern Ireland, because the law of concurrency is actually quite complicated, Thomas. There's another question there from Luke. Would a change order be treated as a relief event or just an amendment to the original contract? Well, it's both. A change order is effectively an amendment to the original contract. Normally, it would be an amendment to the employer's requirements. And your use of the word change order, I'm assuming that you're working in the Republic of Ireland, because that's the terminology used under the Public Works. And under the Public Works, a change order is a compensation event where you would get time and money. You wouldn't only get time associated with that. And that's a common feature between all of the standard forms. Instructions to do something different would normally entitle you to both the time and the money for that. The next three topics, I have bespoke slides for each of them, so I'm going to start rolling through the slides slightly, just for the purposes of moving on. But really good discussion, folks. Do keep these questions coming in, because it really does help everybody in the audience understand the points. So liquidated damages, everybody loves the topic of liquidated damages because, you know, it's quite an obvious thing to understand. If you don't finish the project by a certain date, you owe the employer money, depending on how long after that date you finish. Again, it's a fixed amount of money, but what the law says in this area is actually quite interesting, which bears discussion then. So the point is this: under the law of England and Wales, it's the same in Ireland, it's the same in Scotland, the same in Northern Ireland, civil law does not enforce penalty clauses, okay? The purpose of civil law is not to penalize people. That's what the criminal system is for. You're probably all listening in the news at the moment to the Criminal Bar Association going on strike starting on the 5th of September, coinciding to when the next PM takes over. The criminal courts are completely different to what we're dealing with here in construction. We're dealing with the civil courts, and the civil courts do not enforce penalty clauses. So liquidated damages cannot amount to a penalty. If they do amount to a penalty, they will be unenforceable. So that's the point here. And what all of this law that we're about to look at sets out is, where is the line between something that is enforceable and something that would be an unenforceable penalty provision. That's what all of this law looks at. So the old test that we had for determining where that line is came from this case, all the way back in 1915, the case of Dunlop and New Garage. And the test that we had from that case was this: is the liquidated damages clause and the figure set out within that clause, it is a genuine pre-estimate of the loss. Is it a genuine pre-estimate of the loss? And if the answer to that question is yes, so yes, the figure that we have put in is a genuine pre-estimate of what we will suffer if that contractor doesn't complete on time, then it will not be a penalty. So if we have a genuine estimate, pre-estimate of the loss, it can never amount to a penalty. But for reasons that we will get into on the next slide, that test isn't actually that useful. And ultimately, the law changed pretty much 100 years to the day in 2015, when we had these two cases in the UK Supreme Court. What I'd recommend you do, again, whilst you're listening to me perhaps in the background, go on to the UK Supreme Court website and look up the case of Cavendish or Parking Eye. They were all heard on the same day, and the judgment covers both of them. The UK Supreme Court website is excellent because it sets out a little summary of the decision, again, from the layman's perspective, so it's very easy to understand. And if you're very interested, you can actually go on and watch the hearing. You can go on and watch the trial, watching the advocates and the barristers stand up to argue the case of both parties. It's a very interesting thing to do in your spare time, if you're a bit of a case law anorak like myself. But to go on and explain how exactly the UK Supreme Court changed the law here, let's look at the facts of one of those cases. So this was the Parking Eye and Beavis case, and this is Mr. Beavis. This is Mr. Barry Beavis, who some of you might remember seeing this case in the news back in 2010, 2015, and the years in between. So the point is this: Mr. Barry Beavis received an £85 parking charge for breaking a 2-hour car parking limit. I believe he was parked up at the side of a chippy waiting for his chips, and he overstayed his welcome and he received an £85 charge. That's the factual matrix here. He ignored the parking demand and the parking people took him to court, and his argument in defense of his position was this £85 charge is unenforceable because it amounts to a penalty. Remember that old test that we looked at on the previous slide about what used to amount to a penalty, whether or not it was a genuine pre-estimate? Can you see Mr. Beavis's argument here? He was arguing that had I paid my parking, it only would have cost me a £5. You're now charging me 85. How can £85 be a genuine pre-estimate of your loss when the loss you would have suffered would only have been a £5? I hope you follow that logic there. And you know what? He had a bit of a point. If you were to apply that old test from Dunlop and New Garage strictly, that £85 charge probably would have amounted to a penalty. And that was the issue that ultimately had to be wrangled by the Court of Appeal, or sorry, the UK Supreme Court. So the UK Supreme Court decided that the £85 ticket was enforceable. And in doing so, they slightly reformulated the test for what amounts to a penalty and therefore what amounts to a valid liquidated damage provision. And the test is now this. It's not on the slide, but I'll say it for the purposes of the recording. Is the figure, so in this case, the £85, is it proportionate to the legitimate interest of the innocent party? So the question here is this: is an £85 charge proportionate to protecting the legitimate interest of the car parking people? What do you think about that as an open question to the audience? Is £85 proportionate to making sure that people pay their parking fines on time or their parking fees on time? Christy says no, Thomas says yes. No, yes, no, yes. Noman, good to see you, Noman. I'll see you at 3 o'clock as well. Again, you can ultimately debate that point. I'll put it another way. And this is some of the words and the vocabulary that the courts use to describe what amounts to proportionate. Is the figure extravagant? Is £85 an extravagant figure? Is it unconscionable? Is it something beyond all, proportion? What do you think? Is it unconscionable? Is it extravagant? What do we think? Considering that the underlying fee itself was a £5. Subjective, I would say it's probably objective. To the reasonable person, is £85 unconscionable? Well, put it another way, £8,500 is clearly extravagant. It is clearly unconscionable. 850, I would probably say, is very extravagant as well. But when you start to get into the realms of 85, it does fall beneath that unconscionable threshold. And for that reason, the court held that £85 was a proportionate fine for someone not paying their parking fee. So to cut a long story short and to draw this back into a construction context, when you are setting the liquidated damages within a construction contract, the test that you have to comply with and to have to ask yourself is this: is the figure that I'm putting into this contract proportionate to protecting my legitimate interest of getting that project handed over on time? And that should guide you to the level and the figure that you insert into that contract, making sure that it is not disproportionate, making sure that it is not unconscionable or extravagant. That's what you're aiming to do there. So we had one question there in amongst the discussion, again, I think from Thomas. His question is, in relation to a building which is subject to rental income and the rental sales in which the liquidated damages were based but did not materialize, would it become a penalty? The answer is no, Thomas. Again, at that point, the figure that you're putting in was probably based on a genuine pre-estimate of the rental income, which is fair enough. You're doing it under the old law, but looking at the new law, that figure is still going to be proportionate. That's what you expected to lose, ergo it is proportionate. And the fact that you haven't suffered it isn't a defense. It is a liquidated figure. You pay it regardless of whether or not you suffered it. That's one of the other benefits of having liquidated damages. You don't have to go through that exercise of actually proving that you suffered the loss. Having it written into the contract as an agreed damages provision is enough. So hopefully that's useful. Again, I do recommend get onto the UK Supreme Court website, have a look at how they arrived at their decision. They talk about the Dunlop test. They call it, a haphazardly constructed edifice. Some of the language is quite nice, and it is a useful resource to look at. This then is another important legal phrase that I think most people need to be aware of, and it's called a condition precedent. So this is a fancy legal way of saying something has to be done, a condition that has to be satisfied before, again, the word pre, before something else comes into effect. So in this context and in a construction context, these are normally in and around the notice provisions, where a clause of the contract requires the contractor to do something before they're entitled to something else. Prime example is clause 61.3 of the NEC. And that's both the NEC 3 and NEC 4. It exists in the same place. That's the engineering and construction contract. That clause sets out, Mr. Contractor, Mrs. Contractor, you need to notify within 8 weeks of becoming aware of a compensation event before you're entitled to any time and money consequences of it. If you fail to notify, you get no extension of time and you get no extra money. That is a condition precedent. In terms of what the law says about these condition precedents, the leading case that we have in the UK on this is Bremer and Vanden. This is a UK House of Lords decision, which is now the UK Supreme Court. Post, I think it was 2005, possibly 2009, the UK House of Lords became the UK Supreme Court. They physically moved out of Parliament Square and moved across the road. If you're ever in London, you can go in and have a walkabout. It's a beautiful building. I'd recommend that you do it. And that court set out this test for what amounts to a valid condition precedent. It has to do two things. Firstly, it has to state the precise time within which the notice has to be given. So again, in the context of this clause under the NEC, does it state the precise time? Did I state a time frame earlier? Under the NEC, how long have you got to notify a compensation event? Anyone in the audience? I did mention it, but just to see if anyone was properly listening, 8 weeks exactly. So again, if you're under the main contract, it's 8 weeks. If you're under the subcontract, it's 7 weeks. So again, make sure you're reading the correct form. So the NEC does do that. And the other limb of that test, the other hurdle that you have to get over for that term to be valid, is that it has to use express language that the party making the claim will lose their rights if the notice is not given. I don't have the clause in question prepared as part of these slides, but that clause does do it. It sets out in no fewer words, if you fail to give that notice, you will not be entitled to a change to the prices, no more money, nor will you be entitled to a change to any key dates or the completion date. You don't get an extension of time. So typically speaking, the industry construes that clause of the NEC as being a valid condition precedent. So make sure that you're following that if you're under the NEC. That's just one example. This formula is a generic formula. It will apply to any other provision that meets both of those tests. For example, another common one would be not providing a collateral warranty. If you do not provide the collateral warranty within 10 days of being asked, so that's the first limb, you will lose entitlement to any further payment. We can withhold all of your monies until that collateral warranty is given. That's the second point. So again, watch out for these condition precedents. They are a very common feature of construction contracts. A couple of questions then. Thomas Kelly, wording such as likely to result in delay, how is this treated? And if a handover does not occur, when does the event occur? Is it from the non-occurrence or the occurrence? Again, complicated topic, Thomas, depends on jurisdictions as well. I'd recommend that you have a look at the case of Obriscon and Gibraltar. It's a Justice Aikenhead decision dealing with the FIDIC form of contract, and it talks about that date of awareness, which again, I think is the emphasis and the thrust behind your question. So have a look at the details of Obriscon and Gibraltar. We're not going to get into that for the purposes of this session because it's far too complicated for the purposes of now. Next question. In Parking I and Bevis, if the case resulted in a change to the law, rule applied for future cases, did Bevis win as the law at that point of the trial? No, he didn't. So again, that particular decision did not have retrospective effect, nor do many decisions. So the law changed from that point onwards, and ultimately the court was able to decide it in such a way that Mr. Bevis was not able to be successful in his claim now. So there's no retrospective changing of the law there from that perspective. Some people ask then, just on the final slide here on condition precedents, well, that seems a little bit unfair. You know, the contractor has a genuine entitlement to claiming time and money, but because they didn't give a piece of paper, they are now barred from that entitlement. Well, that's one perspective, but you have to think about it from the other side's perspective, from the employers. And a very good judgment on that point is this one. Again, so it's a good judgment for multiple reasons, but for the purposes of now, it touches upon condition precedents. And it sets out that contractual terms requiring a contractor to give prompt notice of delay serve a valuable purpose. That notice enables matters to be investigated whilst they are still current. The point of these notices is to give the employer the opportunity to do something about it at the time. That is why contractors are required to notify it early, so that something can be done about it. Put it like this: if you are constructing a garage and you're paying the builder to construct the garage for you, and they start to put in the foundations and they uncover a problem, you want to know about it as early as possible so that you can make an informed decision about what to do next. You might decide not to go ahead with the garage. You might decide to change the design, to make a feature out of the thing that you have found. There's lots of different options, and that is the point behind these condition precedents, and a notice condition precedent anyway. So, you know, don't look at it from the one-sided perspective that it is unfair. Look at it from the broader perspective of both parties. The final key term that we just want to look at here, and again, I'm putting this in because I appreciate that I'm talking to quite a lot of structural engineers in the audience, and you will care about this one. This is the standard of care. So this one is applicable to professional consultants who are entering into consultancy agreements with clients, and also to contractors who undertake a design and build type methodology. So if you're doing any design work, understanding what the standard of care is extremely important. So this is the standard that you will be required to carry out your design to. Okay, you do not have to carry out the design perfectly, put it like that. You have to carry out the design to the standard that a reasonable professional in your industry, in your field, would have done. So if you're carrying out structural design work, the test is, what would the reasonable structural designer have done? If you're carrying out design on a railway station, what would the reasonable designer of railway stations have done in that scenario? The question is not, what would the perfect designer have done? The question is, what would the reasonable designer have done? Okay, it's a very different standard there. This is what we call the professional standard. What would the reasonable professional in that field, in that industry have done? You will commonly see this standard referred to as the Bolam standard, and it comes from this case here, Bolam and Friern Hospital Management Committee. And again, I've got a little extract from the judgment there, which I think illustrates this point quite well. It's not about the perfect consultant, it's about the reasonable consultant. And it says this, that a man or woman need not possess the highest expert skill at the risk of being found negligent. It is sufficient if they exercise the ordinary skill of an ordinary competent person exercising that art. Again, this was a clinical negligence decision about a doctor. It's got nothing to do with what the best doctor in the country would have done. It's all about what the reasonable doctor would have done. We've got a couple of people just, I'm just going to mute you there, someone in the background. Quite a lot of these cases look at the medical side of things. They look at doctors. By the same token, if you have a junior doctor, or in the case of construction, a junior QS carrying out an activity, the standard is not what the junior QS would have done. The standard is not what the junior doctor would have done. It is what would the reasonable doctor have done. That hypothetical doctor at the back of the room having an understanding of all of the facts, what would they have done in the scenario? This is important for another reason, because it is this standard that most of your professional indemnity insurance will insure up to. Your insurance, your PI insurance, will not cover you for carrying out the works perfectly. They will not insure you against a fitness for purpose obligation. You cannot guarantee that the design will work as intended. All you can do is guarantee that you have done the work using the reasonable skill and care of a competent professional in that field. So when you're reviewing your own consultancy appointments, always make sure that that turn of phrase is there, that you're required to carry out the works of the design using reasonable skill and care. You cannot guarantee that it will be done perfectly. You can only guarantee that it's done to that standard of care. Good. Question here. Thomas has clearly been reading up on his law books. He's got the Headley, Byrne and Heller case here. Not a precedent in professional negligence. The standard of care is higher than the ordinary person. Headley, Byrne and Heller is, sorry, it is professional negligence. It's nothing to do with medical. It's an accountancy case. So your question is it not a precedent that the standard of care is higher than the ordinary person? Yes, it is. That's exactly the point we're making here, Thomas. The standard here is of the reasonable professional, not the ordinary person. Okay, so Joe Bloggs in the street, they are the ordinary person. You don't construe the standard based on what they would have done. You construe the standard based on what the reasonable professional in that industry would have done. So you're exactly right, and that is the point that we're making here. Does that make sense, Thomas? All good? I'll let you type away there just as we move on. So that then takes us on to standard forms of contract. And in terms of standard forms of contract, the question that I always ask people is this: why reinvent the wheel? Construction projects are, generally speaking, structured in the same way. You need a contractor to build something in return for money. And how they go about doing that may differ slightly in terms of methodology, but the contractual machinery isn't altogether different, or it doesn't need to be altogether different. In terms of the standard forms that I have listed on the slide here, again, we've got the JCT, we've got the NEC, RIBA, and FCInstCES, again, some of the most popular standard forms. There are more similarities between them than differences. Put it like that. They are all construction contracts. You can use pretty much any of these contracts to achieve the same outcome. But be careful in doing so, because each of these contracts approaches things in a slightly different way. They allocate the risks between the parties in a slightly different way. They might have slightly different payment terms. They might deal with retention, for example, in a slightly different way. To use a very topical example, COVID-19 was dealt with in completely different ways under the JCT and under the NEC. COVID-19 under the NEC was, generally speaking, a compensation event under 60.119. Because it was a compensation event, because it prevented completion, contractors were entitled to all of the money consequences of that, plus an extension of time. The exact same event, the exact same thing, COVID-19 under JCT, was a relevant event that amounted to force majeure, at least people thought it did anyway. And because it was only a relevant event, that only entitled the contractor to time. Contractors under the JCT didn't get any extra money for having to close the site, having to prolong their operations, having to then work in accordance with the COVID protocols and the social distancing on site. The exact same issue dealt with in two entirely separate ways under the two most popular standard forms in the UK. And I think that illustrates the point quite well, that at the end of the day, these contracts are all for the same thing: getting a job built, but how they allocate some very specific risks does change slightly. Question there from Evren: what about the war in Ukraine and its effects on material prices? Again, that one's not as clear cut under either of these contracts. So again, under the NEC, the only real way that you could claim the war in Ukraine is under that same compensation event, 60.119. And for that compensation event to be triggered, the event has to cause delay. It has to not have been allowed for by either party. So neither party could prevent. And lastly, the reasonable contractor, or the experienced contractor, to use the NEC phrase, would not have allowed for it at the contract date. All of those boxes have to be ticked off. And the problem with the war in Ukraine is that at this point, it might not necessarily be causing delay because we can still get materials. Again, some projects might be slightly different, but the problem is that the material prices are increasing, and that compensation then doesn't provide for it. So claiming additional prices due to that compensation event is actually quite difficult. The other way of maybe doing it under NEC, if you have option X1 included, that is the material inflation clause or the price adjustment for inflation, you might be able to claim additional money via that mechanism, but most NEC contracts, in my experience, don't have that option within it. And it's even more difficult under the JCT. At best, you could argue that it's force majeure, but same thing as COVID, that would only entitle you to an extension of time, no recourse to additional money. The Ukraine situation would only apply to materials like steel or sourced from Ukraine, absolutely. So again, it's even more difficult to prove that. So the war in Ukraine, unfortunately, is probably a contractor risk. And that links into a more general point and a more general principle as well in terms of risk. The general point is this: if your contract doesn't allocate the risk, the general position is that the risk lies with who? And that's a question for the audience. If your contract doesn't expressly allocate a risk, generally speaking, who takes that risk? Michael's got the answer right. Famaz has got the answer right. Thomas has got the answer right. Everyone, unfortunately not. The general position is if your contract doesn't mention a risk, it lies with the contractor. Prime example here, ground conditions. Ground conditions is not mentioned in the JCT. Therefore, it lies with the contractor. And again, that list goes on. The war in Ukraine and the material prices that we're suffering at the moment isn't mentioned in the contract, therefore lies with the contractor. Good. So again, good discussion there, folks. There's one more question from Thomas. How would government legislation like sanctions affect the contract? Again, depends on the contract that you're dealing with here. Under the JCT, government intervention is only a relevant event. It would only entitle you to time. Under the NEC, it depends what way you've got the option clauses set up. If you have option X2, that would transfer the risk to the employer. Otherwise, it lies with the contractor. So again, all of these points are illustrating the same thing, that these contracts deal with risks in subtly different ways. So making sure that you've read and understood them is obviously of paramount importance. So moving on then, this links into what we've been talking about on the previous slide. So when it comes to risk, generally speaking, there are three different ways to allocate risks between the parties. You can allocate it to the contractor, or linking into your question, Christy, in a subcontracting scenario, you could give it to the subcontractor, or you could allocate it to the employer. Using your example, Christy, that would be the contractor. Again, it's just a different level in the supply chain. Or you can share it between the parties. So for example here, the war in Ukraine, or perhaps a labor shortage, generally speaking, that would lie with the contractor. You might have other things, however, such as lack of access, perhaps government intervention to an extent. You might have weather, for example, that is shared between the parties. And this is what the contract will do. It will name the risk, that's what it should do anyway, and it will allocate it to one of the parties so that both parties understand what will happen if that risk materializes. So to illustrate the point, this is what it looks like. This is what the landscape looks like under the JCT design and build. It's very similar under all of the other contracts in the JCT suite. That some of these risks that have been identified only entitle the contractor to time. Deferred possession, force majeure, the likes of COVID-19, strike or lockout. That's another very, topical risk that's happening at the moment. If your workforce can't get to the site because of the train strikes in England, that will only entitle you to an extension of time. You don't get the prelims associated with that because under the JCT, that risk has been allocated as a relevant event, as a time-only event. On the other side of that coin, we have the time and money events, such as changes, variations, to use the standard building terminology, certain contractor or employer instructions, delay and development control, acts of prevention by the employer or employer's persons. So again, there are certain events that will entitle a contractor to money under the JCT, but generally speaking, it prefers to give time. Getting time and money is slightly more difficult. Thomas Kelly, civil disobedience and insurrection, to my knowledge, isn't mentioned under the JCT. It is mentioned within clause 80.1 of the NEC, but generally speaking, it will be a time-only event if it is mentioned in the JCT. But we'll come on to that when we look at the NEC now. So on the other side of this coin, you have the JCT here, where you've got this split between time-only and time and money events. Under the NEC, that split doesn't exist. So again, this is the only contract that I'm aware of that does it in this way. All of these employer risk events, all of these relief events are time and money. So if they occur, they will allow the contractor to claim both an extension of time and all of the money that goes along with that: prelims, disruption, prolongation, etc. Change to the works information, archaeological fines, dealing with issues on the accepted program, employer breaches. Your point, Thomas Kelly, civil disobedience, war, insurrection, all of those events under the NEC are listed in clause 80.1, and they are also compensation events by virtue of clause 60.114 if you really want the reference. And all of those events are time and money. So if your site has to close due to a piece of civil disobedience, whatever the case happens to be, or you don't get access, or there's exceptionally adverse weather judged against the NEC test for that under 60.113, then you get the time and money consequences, which is entirely different to the JCT. It's entirely different to the public works if you're working in the Republic of Ireland. And so do make sure that you understand how your standard form deals with these very common issues. Good. That then takes us on to looking at payment. Again, we'll get through payment relatively quickly because it is quite straightforward. It's a very regulated area. And, to cut a long story short, all construction contracts have to look a certain way when it comes to payment. So in terms of what the legal landscape looks like here, if you're working in England and Wales, or if you're working in Scotland, then that's the law that applies. The Housing Grants, Construction and Regeneration Act of 1996. And that piece of law is effectively a framework. It sets out that your construction contract has to do certain things. It has to give the parties to that contract the right to interim payment, so the right to be paid on an interim basis. It has to give those parties the right to walk off the site if they haven't been paid. Again, you have to give a notice, 7-day notice, that if you're not paid within those 7 days, you can walk. And adjudication, the right to that 28-day dispute resolution process that we'll cover at the end of this presentation. The right to get paid quickly is the emphasis behind the Housing Grants Act. If you are in Northern Ireland, we have a devolved version of that Housing Grants Act. It pretty much does exactly the same thing, but the clause numbers are slightly different. That's the only real difference. And that's the Construction Contracts Order of 1997. I mentioned at the start of the slides, if you are in Ireland, there is now an Irish equivalent of this. It's subtly different. You do need to treat it as its own separate beast, but that is the Construction Contracts Act of 2013, which applies to all contracts entered into after July 2016. So all contracts that you're probably dealing with at the moment are subject to that act. And it does something very similar. It gives the parties the right to be paid, the right to suspend, and the right to adjudicate them. So, broad brush, this is what that right to payment looks like. If your contract is over or estimated to be over 45 days in duration, then it has to do this. It has to provide an adequate mechanism for determining which payments become due. It has to give you a mechanism for determining due dates for payment. And also, that should be an and, it has to give you the ability and to provide an adequate mechanism for determining the final date for payment. So again, contracts that are over 45 days have to do both of those things. In In terms of what the law also says then, so we have that Housing Grants Construction and Regeneration Act, or if you're in Northern Ireland, we've got the Northern Irish cousin. If you're working in the Republic of Ireland, there's an Irish version as well. Again, subtly different, and do treat it as its own beast. But for broad brush purposes, it sets out those three key rights that we looked at. So your contract has to fit within that legal box. It has to comply with those pieces of law. If it doesn't, then the law will rip out the offending part of your contract and will replace it with a compliant version of that particular part of your contract. And you will find those compliant versions within a separate document, and that document we call the scheme for construction contracts. There's a Northern Irish version, there's an English version, there's a Scottish version, and there is also an Irish version embedded as a schedule within the Construction Contracts Act. So if your contract fails to provide due dates, you bring in the relevant part of the scheme and it effectively updates your payment terms to make them compliant. And this is what it will ultimately look like if you're to plot it onto a diagram. So every construction contract in the UK has to look like this. It must give you a mechanism for determining these due dates. The standard period between those due dates is 28 days, but you are free to amend that if you so wish. You can increase it to 60 days, 65 days, whatever the case may be. You are free to agree these interim periods. The other critical thing that your contract must do, the other structural point that must be present, is it must provide for a final date for payment. And this little process repeats at every due date. So again, what we're about to look at here will happen in the second due date, third, fourth, fifth, and so on. So at every due date, you have to connect to it a final date for payment. The default mechanism sets out that it should be 17 days, but again, you're free to change that timer if you want to. You could set out that it's 30 days, 35, or whatever. What you also have then within the Housing Grants Act and the scheme are a couple of certificates. And again, most people in the audience have probably heard of this if you're dealing with commercial side of contracts anyway. We have the payment notice and we have the pay less notice. And what these certificates do is they enable the person making the payment to dictate how much the payment will be. So let's use an example. If I'm a contractor or a subcontractor and I put in an application for payment of 100k, £100,000. The payment notice is the first bite of the cherry for the payer, the person making the payment, to tell me how much I'm due. And they might decide, you know what, we've looked at your application for payment, we've done a measurement on the site, and you know what, you've actually only done 90k's worth of work, and that's how much we're going to pay you. And that's the point of a payment notice. And it must come within 5 days of each due date. Again, that's the default time frame that you have to stick to. Time marches on a little bit, and it turns out, you know what, our original certificate was wrong. You didn't actually do 90k's worth of work. They can then decide to pay less, and they might even decide to pay them, you know what, we're only going to pay you 70,000. And you can do that via that second bite of the cherry via a pay less notice. Trust me, this looks simple on the screen, but this can get very complicated because these payment terms are not often drafted appropriately. And if you make one little mistake in the drafting, the whole thing can fall down. It becomes extremely difficult to interpret. And the really important thing to bear in mind is this. If you get one of these notices incorrect, if that notice is invalid, then what the contractor originally asked for will become due or could become due by default. So if the contractor asks for 100k and you do not serve that payment notice correctly, and you then fail to serve a valid pay less notice, the contractor is entitled to the full 100k. Regardless of whether or not they have done that work or not, you have to pay them that money by default. And if you're interested in that area, that's what we call, in a colloquial way, a smash and grab adjudication. It's a very common type of adjudication to see these days, based on a technicality of not serving one of those notices correctly. So That then takes us to our penultimate topic. And again, we will be wrapping up in the next 5 minutes or so, so make sure to stick with me. And that is the topic of claiming time and money, additional time and money. So what I've put on the screen here are what I would call some typical sources of claims: variations, late provision of design information, not sticking to the accepted program, lack of access, weather, changes in law. Again, you only have to have some experience on a construction contract to see some of the things that contractors will be claiming on a daily basis. And the procedure thereafter is always the same. It's a 3-step process. Number 1, you have to identify where in the contract you are entitled to claim that particular matter. If you're under the NEC, you look at clause 60.1. That's where you will find the compensation events. If it's JCT, you look at clause 2.26 and 4.20. Those are the 2 clauses that set out the time events, the relevant events, and the money events, the relevant matters. So again, knowing where to look in the contract is always the first step. So you find your entitlement, and that's how you ultimately start to drive your claim forward. The second thing you must do is make sure that you have notified it correctly. We talked about that legal phrase earlier of a condition precedent, that term of a contract that requires you to do something before you're entitled to something else. So make sure that you're correctly notifying will be the second point. And then the third thing, once you've got over those procedural hurdles, you actually get into where the work is, and that is actually proving the effects and proving with reference to adequate records how much the event has cost you. So this then leads us into this very important topic of the burden and standard of proof. When it comes to any claim in the civil side of our society, it is up to the person making the claim to prove it. Okay, it is not up to the other side to disprove what you're saying. It is up to you to prove it in the first instance. So if you're making a claim of £100,000, you need to demonstrate that you are entitled to that £100,000. That is what we call having the burden of proof. The burden rests on the party making the claim. He who asserts must prove. The second question related to that is, well, to what standard must I prove it? And when we're dealing with civil law, that standard is on the balance of probabilities. Is it more likely than not that I am due the money? Is the question you have to ask yourself. The question is not, do I have to prove it beyond all reasonable doubt? That is not the standard in civil law. That's the standard in criminal law. The standard here is to prove your claim on the balance of probabilities. So that takes us to our final topic in the last couple of minutes, to look at dispute resolution and to give you an idea of what dispute resolution methods are available in the construction industry. So the way I like to think about dispute resolution is on this spectrum. At one end, we have the flexible, consensual and informal ways of resolving disputes, such as negotiation, through to the other side of the spectrum, which are far more rigid, formal and imposed. And again, you can probably guess what will fall into that side. That's the likes of high court litigation and arbitration. But these mechanisms very much do exist on this spectrum. We have mediation, towards the left-hand side, but definitely not as informal as a negotiation, where you have an impartial third party coming to help you mediate your solution. And somewhere in between that and the more formal end of the spectrum, we have adjudication, which is what I'm going to talk about on the next slide. So adjudication, in a nutshell, it is a 28-day dispute resolution process. People have this misunderstanding of what disputes look like in construction in the UK anyway, that you have to go to court and it's going to take weeks and months and potentially years. Well, you don't have to do that, because in the UK, we have that statutory right under the Housing Grants Act that we looked at earlier to adjudicate. Any party to a construction contract has that right. And the point of that process is to hand over the documents to a neutral and independent third party that we call an adjudicator. And that adjudicator will decide who is right and who is wrong. And the point is this: you have to follow that adjudicator's decision. they will give you a piece of paper. It might be 15, 20, 50 pages long, setting out their decision. But at the end of it, they will give an order, and you have to follow that order on a temporarily binding basis. It's a pay first, argue later mechanism. You do what the adjudicator says, but if you're still very unhappy, you can then take it on to court afterwards. Okay. There's a question there from Nuberdeen Massa. Is adjudication the same as arbitration? The answer is no. Arbitration is a final form of dispute resolution. Okay, it can take weeks, months, years, perhaps. Adjudication is a 28-day process. They are not the same thing. The main point of difference between them, aside from the very clear difference in the timeframes, is that arbitration, you can't challenge the decision. Once the arbitrator arrives at their decision, unless they've done something very, very silly, that decision cannot be challenged. But you can challenge the decision of an adjudicator. You can do that in court or in arbitration itself, or you can decide to waive the decision. So they're certainly not the same thing. So, final slide then, just to give you a very quick overview of what an adjudication process looks like. I'll just march on the animation just to talk over it. So it all starts with the decision to adjudicate. The actual process starts by issuing what we call the notice of adjudication. Very straightforward thereafter. Within 7 days, you get an adjudicator appointed. So you go to the likes of the ICE or the RICS. They will appoint this neutral third party. Within 7 days, you give that individual all of the documents, and within 28 days thereafter, you get a decision. It is as straightforward as that. Adjudication is a very, very straightforward process. There's no trial. You don't get to stand up and give your evidence orally. The adjudicator might ask for a meeting perhaps, but it's very, very unlikely to happen. And all of these key points have to be considered within that very short time frame, 28 days. The 28 days can be extended by agreement up to 42 days or even beyond that in certain circumstances. But aside from that, it's a very, very straightforward process, and it is not the same as arbitration, and it is certainly not the same as court. So about 5 minutes over, I do apologize for keeping you all away from your lunch, or perhaps you've been eating your lunch as you've been listening, in which case, not too bad. But thank you all very much for joining this IStructE event today. And there's my email address. If you do have any questions that I couldn't get to, feel free to drop me an email and I can pick those up offline. I will be issuing a CPD certificate to anyone that has joined us, so do keep an eye on your inbox for that. But aside from those matters, that's everything from me. Thank you all very much.